Many people mistakenly assume that securing a green card from inside the United States is a purely mechanical process. You fill out the correct forms, pay the required fees, pass a background check, and wait for your approval. In May 2026, the U.S. government released a policy memorandum that challenges that assumption. The title of PM 602-0199 explicitly outlines how the agency actually views these applications. Adjustment of status is a matter of discretion and administrative grace. Under these rules, an applicant can meet every single technical eligibility requirement, proper inspection, valid status, clean background, and still receive a denial. The Board of Immigration Appeals and the Supreme Court classify adjusting your status from within the U.S. as an extraordinary form of relief. It functions as an exception to the standard immigration process. Because you are asking for this exception, you are entirely dependent on a single officer's discretionary grace. To understand why the scrutiny is so severe, we have to look at how Congress designed the immigration system. The baseline expectation is that immigrants complete their visa processing abroad at a consulate before arriving. When an individual is paroled into the country or admitted on a non-immigrant visa, like a tourist or student visa, they are granted entry for a temporary, specific purpose. The legal expectation is that they will leave when that purpose is served. Filing for a green card without leaving the country directly contravenes that expectation. It bypasses the orderly international consular process. Therefore, adjudicators approach an in-country application with a baseline assumption. The applicant is attempting to sidestep standard immigration procedures. To visualize how USCIS officers must decide these cases, we can look at this balancing scale. Every application is measured by weighing positive factors against negative ones. Because Congress prefers consular processing, the mere act of applying from inside the U.S. is immediately counted as an adverse factor. You begin the evaluation with a heavy weight already sitting on the negative side of the scale. If an applicant has overstayed their original period of admission or engaged in unauthorized employment, these violations stack on top, driving the scale further into the negative. Most people adjusting their status are starting their case from this deep deficit. Submitting a standard error-free application is mathematically insufficient to pull the scale back to neutral, let alone secure an approval. To overcome that inherent deficit, the 2026 memo explicitly states the applicant must prove unusual or even outstanding equities. Positive equities are concrete social, economic, and humane factors that demonstrate why granting you permanent residence benefits the United States. This includes profound family ties to U.S. citizens, exceptional moral character proven through deep community involvement, or a history of significant contributions to the American economy. A critical detail from the policy: the absence of bad behavior does not count as a positive equity. Submitting proof that you have no criminal record does not push the scale upward. It merely confirms you meet the bare minimum statutory requirements. The adjudicator must weigh all the evidence and make a final determination on whether the applicant is ultimately suitable for permanent residence and if their approval serves the national interest. Winning a green card from inside the U.S. requires an active campaign. You have to build an overwhelming portfolio of positive value to decisively overcome the negative deficit. If an officer decides the scale leans negative, the 2026 mandate requires them to rigorously document their refusal. They must issue a formal written analysis, explicitly listing the positive and negative factors they considered, and explaining precisely why the negative factors outweighed the positive. Once the Secretary of Homeland Security, acting through the USCIS officer, makes this discretionary judgment, the statute categorizes it as an unreviewable decision. Federal courts generally do not have the jurisdiction to second-guess this specific ruling. Failing to aggressively present your positive equities at the very beginning of the process results in a legally binding rejection that is exceptionally difficult to appeal. Every adjustment of status application functions as a high-stakes legal argument for administrative grace. This is why an applicant requires a legal strategist. A professional identifies the outstanding equities you may not realize you possess, documents them thoroughly, and forces the adjudicator to weigh them. Secure your future. Book a strategic consultation with the NYC immigration lawyer today to evaluate your case. In a system defined by hidden discretion and strict burdens of proof, a proactive legal strategy is the only reliable way to tip the scales in your favor.